The public meeting of the City of Tallahassee Independent Ethics Board is now called to order on this day, Tuesday, March 19th, 2024 at 4:27 p.m. Board members are present here at City Hall along with members of the public. With the assistance of the Communications Department and the Information Technology Department, this meeting is live streamed on the Ethics Board's website and we are recording it for future reference. There is a delay with online communications and we should all be patient. As always, we thank those members of the City of Tallahassee for their support. For those attending the meeting online, please make sure your microphone is muted. Last week, we asked the public to email ethics@talgov.com by 1 p.m. on the day of meeting if they wish to speak online or on agenda or non-agenda items. Those who have submitted their names will be allowed to speak as scheduled. While the meeting is in progress, please do not speak during the board's discussion. We have set aside 2 places on the agenda for the public to speak. For those who wish to make a public comment, please complete a speaker request form and forward it to the administrative specialist, Ms. Tasker Leverson Green. Be sure to state what you wish to speak about on the form. Public speakers will be given up to 3 minutes in accordance with the board's bylaws. Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Have the roll call.
Kirsten Costa.
Here.
Patrick Kelly.
Here.
Carlos Ray.
Yep.
Rico Calhoun. Adam Commissar.
Here.
Madam Chair, the physical presence of 4 or more board members is required for a quorum. Since we have fewer or less, no quorum is formed.
So we will not be able to vote on anything today, but we will still go through the agenda items and discuss things as they come up. While we can't approve the minutes currently, does anyone have any changes or concerns about the minutes from the last meeting? Seeing none, we will hold off on voting for that approval for next month. Any public comment on agenda items? No. Okay, moving on to the Ethics Office report.
Members of the board, I provide you a snapshot of our activity since last February. As we do every month, we conducted virtual training for new employees and presented at the new member orientation. We responded to requests for an advisory opinion. We extensively monitored legislative activity affecting the board's business, and we coordinated with other ethics boards and commissions throughout the state and at the State Ethics Commission as well. We attended charter review committee meetings and started redrafting the Citizens Ethics Guide. We conferred with the board chair, maintained the Facebook page, and responded to ethics complaints. With regard to the budget, expenditures not listed, including an annual fee to remain as a member of the Council on Governmental Ethics Laws, and that was $445. And we paid a biannual fee for training. Toastmasters International asked Tasker to attend Toastmasters. They have a speech program. It's 10 speeches. And that's part of the training that I'm doing with her to prepare her to assist with employee training and making presentations. So it doesn't get stale with me and I don't have to always carry the load. Those were the expenditures except for the routine things that you see. Next month we'll have a lot more and we'll talk about that next month. But that's all we spent money on this month. Any questions about the budget? And if you don't mind, Madam Chair, we'll skip the issue tracking since we can't vote on it, and we'll bring that back.
And that moves us on to the general.
General update, have a couple of things. We're still waiting on FSU and the city to fill their vacant seats. As far as I know, the city only had 3 applications last I checked. I don't know how they're advertising them. I know last time we did it, we had more than a handful, but they're still trying to get applications, so. After that, as you know, FSU's person, when they hired their ethics person, it turned out he lives outside the city, so he's not eligible. So they're doing a follow-up to try to get a person, and I reached out to them, but I haven't heard back. And those are things for the general update.
Next, any questions on those? Next is the legislative update.
Okay, John's going to provide that.
So the legislative session just concluded 2 weeks ago. There were 2 bills that we were monitoring. One may or may not affect the ethics board. One will definitely affect the ethics board. So I want to go through both of those. First was House Bill 601, entitled Law Enforcement and Correctional Officers. This bill was covered quite prominently in the media. This was the bill that abolished the police citizen review boards. Citizen review boards have been somewhat controversial. It's been a political football here in Tennessee. It's been around the state. So there was this move to eliminate them altogether. So effective July 1st of this year, all citizen review boards will be disbanded, and any ordinance authorizing citizen review boards or agencies will be void. The bill doesn't reference ethics. However, the language was extremely broad, and there is some concern that there could be unintended consequences. The bill amends section 112.533 of Florida statutes, and it reads that a political subdivision, which would include the city of Tallahassee, may not adopt or attempt to enforce any ordinance relating to either of the following. A, the receipt, processing, or investigation by any political subdivision of the state of complaints, misconduct by law enforcement or correctional officers, except as specifically provided in the section. And then B is civilian oversight of law enforcement agencies, investigating complaints of misconduct by law enforcement and correctional officers. The first one is the one that is an issue. It says that cities or any political subdivision cannot investigate complaints. Debate during the bill on the floor, it seemed to really be primarily aimed at conduct taken in the act of being a police officer. However, the word was broad enough where it could, in fact, extend to an ethics complaint. And the bill is meant to avail the Law Enforcement Bill of Rights to any law enforcement officer who is the subject of a complaint. As I said, that language is so broad it could be interpreted to include ethics complaints. The language is unclear. We've discussed it with some people around the state, and nobody seems to agree on whether it would include ethics complaints or not. So at this point, we're going to simply just continue to research the issue and talk to some other folks around the state and the local government and see if anybody can figure out what the bill is going to do and whether it does kind of scoop us into that area. So
Yeah, if I may, the bill analysis doesn't speak to that. And when I talked to the executive director of the Chiefs Association, she didn't think it could impact us. However, it's the language itself that's concerning. So, as John said, we'll see where that lands.
Yeah.
And we should also note neither done by the governor yet, even though we very much expect these.
that the one we just discussed was a big priority of leadership, so I expect that will be signed relatively soon. The bill that does directly affect us in a really big way is Senate Bill 7014. This was a committee bill from the Ethics and Elections Committee carried by its chairman, Senator Danny Burgess. The bill was at the beginning, a good bill. It provided some timelines for how complaints were to be processed with the Florida Commission on Ethics. Didn't address anything with local commissions or boards. A lot of that was, there was a prominent case, the state commission dealing with a former state senator, went through the years and years of litigation, depositions, et cetera. They finally reached into a stipulation. The board rejected the stipulation and said, start all over again. The witnesses that had been called into that said, we don't want to participate anymore. So the case crumbled and they ended up having to dismiss the complaint outright. So this bill did appear to remedy that situation specifically, which did make some sense. So we saw the bill, didn't really consider much of it because it just dealt with the State Commission on Ethics. The bill was scheduled to be heard on the Senate floor for its second reading at 1 p.m. the day before, January 31st. A number of amendments were filed, including one that directly affects us. The amendment would do several things. It would require all complaints to be signed under oath. It requires complaints to be based upon personal knowledge or information other than hearsay. It prohibits local ethics boards from self-initiated complaints or self-initiating investigations, and requires all local ethics boards to provide for a prevailing party clause. So anybody who is found to have filed a frivolous claim could be assessed attorney's fees. That last one we already have, and ironically, I think every single local commission already had that language, but I wanted to make sure that that was in there. It's important to point out that this language was never discussed in committee. It came up at the 11th hour on the floor, was amended to the bill. Typically, when a bill is heard on a special order calendar, it rolls over and then is heard on a separate day for its final reading and then passed. In this case, the Senate amended, they waived the rules, passed it on the same day, and it immediately passed out of the Senate. There were some questions raised by a couple of the senators that had some concerns. What does this do? Why are we just seeing this for the first time? But it kind of pushed through and it got out of the Senate relatively quickly. It went over to the House where its companion bill still had one committee stop left. So we, as Dwight mentioned, worked with a lot of the other local ethics commissions and boards to try to reach out to members and find out what they were going to do. And it's going to really essentially gut a lot of what local ethics boards do. And we went to the last committee of reference in the House to speak against the bill, but the bill was kept clean. It didn't have the local ethics board language on it at that point. It then was set for special, or no, it came over messages from the Senate. At that point, the sponsor of the House introduced the amendment with the local ethics board language. So again, it was not subject to a committee. It was simply sprung on to the floor. We engaged in, I think, a pretty aggressive effort reaching out to members to let them know what this was. The media was quite active with a lot of articles. The Florida Times Union out of Jacksonville had the best headlines: state legislation would turn local ethics watchdogs into lapdogs. And essentially it just talked about how a lot of what we do essentially be completely decimated by this bill. The bill did, like I said, pass the Senate without much discussion or debate. And it didn't appear that the members really understood what this was or the gravity of the bill. Like I said, in the House, it never was brought up it was discussed in committee, but it was not proposed in committee. Some members asked, is this going to be sprung on us on the floor? And the sponsor wouldn't say yes or no, but then we did end up introducing it on the floor. A number of representatives spoke out. I want to point out State Representative Ashley Gant of Miami was probably the most vocal. I think there were some suspicions that a lot of this was aimed towards the Ethics Commission out of Miami that has been very active in not only investigating ethics complaints, but working with law enforcement. There's a former Miami City Commissioner who was recently indicted That began through a self-initiated investigation by the Miami-Dade Ethics Commission. And now those types of investigations would be prohibited from taking place. A lot of what we have done in the past, where people have brought issues to us, maybe they're fearful, they don't want to take a chance that they're going to lose their job because they're saying something. We can no longer, we can't even look at the issue anymore, let alone self-initiate a complaint like we've done in the past. We can't even investigate the issue. Essentially, it just ties our hands until somebody brings us a signed, sworn complaint. One of the other issues that was, and then I do want to point out that because of these changes, we do have some administrative procedures that we've previously adopted. I'm going to work on that over the next month because we're obviously going to have to change that to essentially take out the entire section deal with self-initiation and some of the evidentiary standards that we apply. Language that was concerning, particularly to me, but also some others, was the language pertaining to hearsay. And as I mentioned, the language says the all complaints, the ones that are filed with us, should be based upon personal knowledge or information other than hearsay. Does not say anything about the hearsay exceptions. And that was the part that a lot of us started raising concerns about. Now, the hearsay rule, I think most of our board is attorneys, I think. We know an admission is an out-of-court statement that could be used, state report, business record. These are all hearsay statements or documents that are generally allowable under the Florida rules of evidence. And we were concerned that now those documents would no longer be available. One that we raised is an inspector general report. If an inspector general does research and finds that maybe some money was being misappropriated and it clearly fell within our misuse of public position ordinance, we'd have to sit back and just do nothing. The issue was raised on the floor. The sponsor of the bill pointed to a case out of the 4th DCA that dealt with the Florida Elections Code. Now, this language, the personal knowledge and information other than hearsay, is essentially lifted directly from the Florida Elections Code. And there was a case in 2010 that specifically went to the heart of this very issue. Is the term hearsay the legal term of hearsay, or is it something else? And the 4th DCA said that because using the legal definition would lead to an absurd result, that's the quote, they agreed with the administrative law judge who said, we're not going to use the legal definition of hearsay. We're just going to grab a dictionary and see what does hearsay mean. And essentially, they said it's essentially gossip. So that is good for us, because I think if it was the legal definition of hearsay, we would never get a complaint again. Somebody would have to actually see somebody handing a brown bag filled with cash to another person with their own eyes, and that would really be the only way we'd be able to bring a complaint. Here, at least, this leaves the door open so that something like a business record, a check, we have a doing business with your own agency provision. If we invoices sent, those would be now those can be the basis of a complaint. So, but that was what that bill did. I think they also applied that same standard to the state commission. They, I think, will be going into the rulemaking process and to, I think, essentially, I expect that they're going to adopt the same definition from the 4th DCA so that they don't run into these hearsay problems. And that may be something that we would like to do as well. But that's something that we will get to as this moves forward. So the bill is, I think it's still in the legislature. It's not been transmitted to the governor yet, but I expect that to shortly. And my understanding is that the governor is supporting this bill, and I expect that he will very promptly sign it. So, and those are the bills, fortunately. So,
Thank you both for all your extensive work on our behalf. Any questions about those?
Out of curiosity, I assume that if both are passed, it would kind of gut our Or is the hotline just going to be a referral to a form that you can swear to in the future? Like anything we would get through the hotline. Things that would
Refer them out to somebody else, I guess.
It just seems like a lot of what we get through the hotline is referred out, and it just seems like it's a good resource. Like half the people you're talking to, you're sending to other agencies and actually do things for them. So it would just be a shame that that went away because of this.
Well, I can still refer them. We just can't investigate. It's hard to say how it's really going to impact us from where I sit. Our most relevant, keep in mind is that what we're really after is corruption more than anything. And witnesses are important in doing an investigation. Yeah, and outside of having confidential informants, which we'll get to with whistleblower, but outside of that, we still need witnesses. So it's from where I sit, it's hard. I'm not discouraged at this point because a lot of third party stuff we end up dismissing anyway. We just won't have those numbers, and I'll say repeatedly that we're here to deal with corruption, and only takes one. So our relevance doesn't change. We just have to work hard to make people more comfortable with coming forward, which we were doing anyway. So it's hard to say what the impact is going to be.
And I think we've generally been more of the front end. People come to us, ask for permission instead of forgiveness. I think a lot of the other commissions that we spoke to, Miami-Dade, I think is going to be decimated by this bill. They have a full-blown staff, investigators, advocates, which are their prosecutors. I don't know what they're going to do with all their staff people. Here, we are a pretty bare-boned staff, and we do a lot of advisory opinions, and we try to get out in front and just try to do, and we've gotten lucky in that regard. So I do agree with Dwight. I think we will not be as affected as some of our colleagues around the state. We're a little stunned, to say the least. But yeah, and as far as it says complaints or investigations. So referrals, as long as we don't look into the issue, we can send it out as much as we want.
Only other thing I'll note is, because a lot of this impacts the state, not us. And in my conversations with the state, I would often mention that it's been my experience when you have legislation like this, legislatures also provide funds, because what they're looking for the state ethics commission to do is speed up this process. And it's not like they're sitting on their hands, they need more resources. So they told them to speed up, but they didn't give them budget. I think that in itself is going to make local ethics offices more important because of possibility not having resources, almost like setting them up to fail, to be quite frank. But we're more expedient in investigating cases and getting them to a resolution. So to see how this act, I know what some people intended to do, but I don't think any of them really understand the impact of how it's going to affect them in a way that they didn't see coming. So it'll be interesting.
I could chime in too. I think one of the concerns that was raised is, I guess there was this narrative that we had heard among leadership that the local ethics commissions are out of control, that they're just used for political hit jobs, and they need to be reined in. Now, I think we've not been used in that way, and I think that we are bound under statute to keep these complaints confidential and exempt. The irony is now when something comes to us, it's going to bounce off us because we can't take it in, and now it's a public record. So I think they kind of may have shot themselves in the foot in that regard if they were really trying to protect people's reputations against frivolous claims. But the fact that nobody was brought in, especially some of the bigger commissions for a discussion, we workshopped the issue. It just appeared this was this issue was decided long ago, and going through the votes was just kind of a show. So it looked like the decision was kind of made by leadership, and from what we understood, the governor's office as well. So it is what it is. But like I said, I think we're going to come off better than a lot of our other colleagues. So we'll keep you posted as it develops. And like I said, we'll have to come back and redo our procedures.
And to say very plain what John just said, because I think it's worth reiterating, when somebody makes an allegation about an official or member of the city, we investigate it thoroughly. And when it's not true, we prove it's not true. And the world moves on. We investigated police chief a couple of months ago. The world moved on. Now, if somebody makes an allegation and we can't investigate it, then the allegation is just going to sit out there. And without anybody being able to go out and say it's not true, it's just going to sit out there. So it can become more political than it was before they passed this legislation. I think that's important for people to understand. Any questions?
All right, so next is the Charter Review Committee meeting update.
Charter Review Committee meeting, and let me introduce Dr. Payne. If you watch the link that I sent you, John and I went to we went to a board meeting where Mr. Payne introduced the board's concerns, a wish list, if you would. One was jurisdiction concerning outside agencies, and the other was whistleblower protection. We introduced it in the first meeting. John spoke about one, I spoke about the other. We spoke during public comment. In the last meeting I attended, I spoke briefly. Ms. Payne gave a good presentation. People probably thought he spoke from my notes because what he said was similar to what I would have said, but he didn't speak from my notes. I didn't tell him what to say. He did a very good job. By the time he finished, they were calling him Dr. Payne, even though they kept telling him to call him Mr. Payne. But he did a good job. And the bottom line is, after some discussion, eventually they voted unanimously to support both. With the jurisdiction will only be over the city officials. But from my understanding, the city commission had said they would not consider it unless it was a unanimous vote, and it was on both of those. So we'll see where they take it from there. It's both in their hands. I think given the legislation on SB 1714, whistleblower protection becomes that much more important. We answered a lot of questions because there are, concerns about what it is, it isn't, and have heard concerns about there being confusion. And I would have to say there's no more going to be any more confusion there is now. And frankly, there hasn't been any between the Inspector General's office and the board, as long as we act in good faith and trust and both understand what whistleblower is. They have, as you know, they meaning the Inspector General's office, has shared their procedures, which they generally copied from state. And I would expect that if this passes, we would do something similar. The backup attorney for John specializes in whistleblower protection. So I'm looking to get her involved and help steer the ship and make sure we meet our deadlines and maintain confidentiality where we need to do that. And I think it's also important for people to understand that more than anything, this addresses retaliation and retribution, which is an important part of whistleblower protection. And I think it directly aligns with what we do. And we're only asking for it with regard to those areas where the Inspector General does not have jurisdiction, where he himself brought that to our attention. So it passed unanimously, and it is back with the City Commission to act on.
Mr. Payne, I would like to say thank you for your fervent championing of these causes on our behalf. So thank you very much.
Is the committee included or is it still?
The committee concluded that day, the city treasurer clerk's office is working with them to write a report. And that report will go to the City Commission.
Any other questions? Next would be the advisory opinion. I would guess that we should hold off on that as well since we can't.
Right. Yeah, since we've already given the response to the individual.
So then next would be public comment on non-agenda items. None. Any directives from the board to the chair? Like bringing back the stuff we got to vote on for next month.
Yeah, we'll have that. We've talked about making revisions to an ordinance, and you asked us to bring that up back. But,
Procedures. Changes to procedures.
no, the ordinance, gift ban, procurement
Oh, yeah.
definition.
Yeah.
Yeah, we talked the last time about the gift ban, when we talked about the advisory opinion, and there was something that we thought logically the mayor should have been able to do, but the gift ban didn't allow him to do it. So we wanted to address that and procurement definition because it's too broad. So we'll possibly have that next month. So we'll have plenty for you next month. Okay.
All right, so the next meeting will be Tuesday, April 16th at 4 p.m. And Mr. Ray motions that we adjourn and Mr. Commissar seconds at 59.
We all agree.
Yeah, vote on it.